I beg to mention for listing on IML.
What is the IA about?
IML for suspension of bail.
When do you want it?
This week, any date,
Friday.
Publish.
May I please, Your Lordship? Lordship, I beg to mention for listing of a criminal appeal, Lordship, for hearing, Lordship. For the last 4 years, he has been behind the jail, Lordship, still behind the jail, Lordship. Paper book is ready, can be listed for hearing. Already it was listed, it did not reach, Lordship. Can it be on Friday, Lordship? This is
Not Friday, next week.
next.
Please, Lordship. I beg to mention a IA for listing, Lordship. That is IA for bail for listing, Lordship. That may be taken about Thursday, Lordship.
Friday.
Well, one matter, my lord, criminal appeal, my lord. Lordship said that, my lord, it would take long time, my lord. Your Lordship heard it, and thereafter said, my lord, that bail application may be disposed of, my lord. We mentioned it on an earlier occasion. Lordship said to mention it later, my lord. Can it be any day, my lord, this week?
Monday.
Monday. Monday would be next week, my lord.
What is the problem?
Friday, my lord.
What is the problem with Monday?
No, Monday would be next week, my lord. Any day, my lord.
Then you decide which day.
Friday, Thursday, my lord. Highly obliged, madam. Highly obliged.
Yeah, please, Lordship. I'd like to mention for listing of criminal appeal, Lordship, for tomorrow.
Tomorrow?
Yes.
For what? Listing for what?
Hearing, criminal appeal.
Hearing? Tomorrow? Why? Which year? Appeal of which year?
2019.
Achha. We'll have it on Thursday.
My lord, in item number 61 of the hearing list, my lord, 3 appellant, my lord, inside jail, my lord, 22.
Achha.
22
There is no
meter.
hearing list in this court, I'm told.
My lord, we have filed one, my lord, IA criminal for bail application, my lord, IA criminal 1146 of 23. Can it be taken on Thursday, my lord, 7th?
Monday?
Monday, today is Monday.
Next Monday?
Yes.
Yes.
May I please, Your Lordship? Lordship, I beg to mention for listing of one criminal appeal, Lordship, 11 of 22, Lordship. In this case, Lordship, last occasion report was called for, Lordship, regarding, Lordship, plea of juvenility of the appellant, Lordship. Can Lordship may take Wednesday or Thursday, Lordship? Lordship.
Daily list for admission, item 1.
Jail appeal,
This is
madam.
jail appeal.
Yes.
Is there any amicus?
Nobody's name is reflected. There's a list, madam.
So we'll ask the registry to
Lordship.
engage a amicus
Fine.
and list the matter. Take down. This appeal has been prepared from the jail. None is there to represent the appellant. Mr. Ms. B. We are learned deputy present on behalf of the state. Since the appellant is unrepresented, registry to engage an amicus curiae from the list prepared by this court and list the matter again by reflecting the name of the amicus in the cause list.
Item 2.
May I please, Your Lordship? Lordship is a legalist matter. This matter is appeal against conviction under Section 6 of POCSO. The conviction of RI of 20 years.
You are legal aid counsel.
Yes, Your Honor.
What is the ground of appeal?
The appeal is based on the ground of contradictory evidence, inconclusive medical evidence, and incomplete and improper investigation.
Please show us. Argu. You are smiling. You show us how the grounds arise from the judgment.
Mother of the victim.
Respond number 2, that is the mother of the victim, to the officer in charge of the concerned police station.
You should serve a scan copy of the memo of appeal.
I have already served.
No, scan copy ta dibo, ami email koi
Okay. No.
the learned legal aid counsel to take necessary steps. Yes,
My lord, conducting counsel is in another court. The matter may be taken on another day.
no, but you are there in this case. What is your name?
You wrong please.
Huh?
You wrong please.
Rumpi, you are there in this case.
I'm not.
So tell us, what is this about?
I'm not ready for this.
Huh?
I'm not ready for this case.
You're not in this case.
He's not ready for the case.
Why you are not ready? Get ready.
He will be there after some time.
We'll call after 15 minutes. You get ready. You come to the High Court to practice and you say, I'm not ready. What kind of a submission is this? You are practicing in the High Court, is it not? You flaunt your High Court advocacy outside and inside you only take time. Get ready. After 15 minutes, tell us what is the ground.
I can settle.
In also cases, notices, but why do you say it is mandatory? Passport, yes. Right. That we'll just examine. Deepak Nayak judgment.
Deepak, I have got
Is it made mandatory in that judgment that
para
notice
9,
on
my lord,
victim-
may I have a look? Mainly in POXO.
notice on victim mandatory?
Serve a copy of such bail application, so and so to public, shall forward the same so and so through email, also hard copy. Maybe while making victim shall be properly screened. Roshi, may kindly have a look. There are 8, 9, 9.
1 minute, Mr.
You
Biswas.
know whatever.
No, that 376. So if apa ba disilo? Wala sila. Wala sila.
Where is it mentioned that the mandatory is and then
Deepak Nayak. Ba ulay sa agote.
No, no,
Last
where
time ulay sila.
is what you are saying is not here. Is there anything else mentioned in the He says it will serve to the public prosecutor. Who in turn shall forward the investigation?
Most of it.
You say the court only mode of service is to the concerned officer, not by minister.
Itas. Kona bole. Jadi sana.
No, there is no such guarantee. It is to be served upon the prosecutor. Prosecutor will do. So that is for them, not for the court. So these are two different things. The court
We saw to what to,
directing,
So
in every
people
case,
know.
if the direction is issued,
you know?
then it should have other than sufficient. So anyway, that direction,
Mhm.
we go through. Yes.
May I please your lordship, this is a statutory appeal, 302 is there, my lord.
Hmm.
I pray that it may be admitted, my lord.
What is the ground?
Ground is, my lord, there was a provocation from the DC. That was not considered, number one. Number two is the independent witness has not supported the case. The family witnesses have supported the case. Then number three, my lord, the other medical evidence and other cases are there. And there are 4 persons are accused, my lord. And who has given the fatal blow? That has not come to the conclusion, my lord. All 3 have been acquitted, only old father has been convicted.
Lordship may admit it.
Yes. Heard Mr. S. C. Biswas, learned counsel for the petition appellant, also heard Ms. B. Bhuya, learned senior counsel in application, assisted by Ms. So-and-so, appearing for the state. This appeal is directed against the judgment in order dated 12/10/2023, passed by the learned Sessions Judge Sonipur, Tejpur, in connection with Sessions Case number 271/2017, convicting the appellant under sections
Okay, coming to this. Coming to this.
conviction is under 323.
323, 341 and 302.
302/323/341 of the ISC, of the IPC, and sentencing him to inter alia undergo rigorous imprisonment for life and also to pay fine. We peruse the grounds taken in the memorandum of appeal. Stop, admit the appeal, call for the LCR, issue notice returnable in 4 weeks. Since the state is represented by Ms. So-and-so, no formal notice is required to be sent to the said respondent. Notice be however sent to the respondent number 2 by registered post with AD within a week, making the same returnable in 4
Lordship may not be necessary.
No, why?
302.
He's an informant. He has made them a party.
I made already.
302 matter may not be necessary.
No, but if he wants to
Oh,
just do
okay.
so.
Yes.
If you are, lordship wanted, delete it, I have got no objection, I made
No,
it.
no, he is the informant.
Yes, he did.
Let the notice go. If
Yes,
it doesn't turn out,
yes,
we'll
ma'am.
see.
But he is to send by registered post.
Yes.
But there is a IA for bail murder, let,
I'll file objection, madam.
yes.
What is the IA number? Let us see.
I number, लगता नहीं.
IA
I number
1164.
1164.
Heard Mr. Biswas, the counsel for the applicant. This IA has been filed under section 389 of the CRPC. Praying for suspension of bail sentence and for releasing the applicant on bail. Ms. B. Bhuya, learned application placed for some time to file objection. How much time you want?
4 weeks.
4 weeks.
3.
3 weeks.
That's a 3 weeks time to file objection, prayer allowed. Let the matter be listed after 3 weeks.
Lordship. List.
May it be statutory appeal, my lord, convicted under section 6 of the POCSO Act for 20 years, my lord.
Yes,
May it be, Your Lordship. Your Lordship, the appellant is convicted under section 376 for 20 years. And Lordship, the victim in the present case is aged about 35 years. And I'm mentioning the age because Lordship, there is delay of 5 days. And that is not properly
5 days in
explained,
lodging FIR.
in lodging the Azhar.
And
All right, we're admitting it because it's a statutory appeal from jail. But we are not at all happy with your level of preparation. You have, if you are not interested in the case, what are you going to do in the hearing only? In the hearing also, you will just,
No, no,
Hmm.
the matter is,
you are not being able to say what is the ground on which you are seeking interference with the order of conviction. Second
No.
chance, you are not being able to say that. You are giving particulars of your ground, not the ground.
and you're not,
Hmm? You need to understand how to argue a criminal appeal. That's what we are pointing it out. Not satisfactory. Don't take things for granted. It is necessary for you also to understand what you're doing. His appeal from jail has been preferred against the judgment and judgment dated 22/6/2023 and order of conviction and sentence dated 23/6/2023 passed by the Lana Special Judge Pokso, Golaghat in connection with special bracket P bracket close case number 35/2020, convicting the accused appellant under section 6 of the POCSO Act 2012 and sentencing him to undergo rigorous imprisonment for 20 years and also to pay a fine of rupees 10,000 with default stipulation. Ms. So-and-so has appeared for the appellant. Ms. B. Bhuya Lanid, APP, Senior Counsel in APP Assam, assisted by Ms. P. Bora, has appeared on behalf of the
Also be aware of,
it,
yes.
anybody who violates with consequences will follow. Yes.
Item 3.
Sleep slow labor to me.
I apologize, my lord. And on this item today, it's a jail appeal, my lord. After condonation of delay, it has come for the first time for registration. My lord.
Conviction is under?
That I have missed the item, so brief is not fit right now, my lord. May it be on day after tomorrow. my
No,
lord, I
you
will
take the
attend.
brief, go through it and just tell us in 10 minutes we'll call again.
Right now, I can.
Yeah, you go through the.
Basically, so far as I remember, that 313 evidence part was not appreciated by
You
the.
go through it. When you're ready, you call, tell us, she'll call.
Item 4.
Also tell us who's the informant here, what is the
My-
relationship? Yes.
Your
Ready now?
Lordship, my finding is that in the birth
Authority is evaded. Because in this matter, the appellant, in one of the cross examination, it is stated that he has a minor son that is 15 years old. And in the order, there is no, the compensation order was not there. So Honorable Court has directed to make an inquiry and find out the status of the son.
No, but what has happened? The appeal has been admitted.
If Lordship appeal admitted, but that
You are appearing for whom?
I'm appearing for the prosecution, Lordship.
You are the APP.
Yes, Lordship.
And where is the amicus curiae? So no report has been furnished under as per order dated 22/8/2022.
Lordship, it will not, I think. it will
That's a
see.
long, we'll have the State Legal Service Standing Council. None is, the learned amicus curiae is not present, although her name has been shown in the cause list. Mr.
K. Bushra Lordship.
K. Boisho, learned APP Assam is present and has pointed out that the report as called for by the order dated 22/8/2022 to be furnished by the concerned legal service authority has not yet been made available. In view of the above, registry to list this case again after 2 weeks by reflecting the name of Learned Standing Council, Assam State Legal Service Authority in the cause list.
of the Lordship. 11%.
With due intimation to the concerned council.
Item 11.
May it please your lordship. Lordship, may I Pero's order dated 2/12/2022 passed in the interlocutory application lordship by this honorable court.
You are arguing IA criminal 610. Yes.
Here in this case, lordship, the age of the victim is stated to be 10 years, lordship.
Yes.
FIR, your lordship will
Paper book will be required, is it not?
Lordship.
So let the registry expedite preparation of papers. Heard Ms. D. Borpujari, learned counsel appearing for the appellant. Also heard Mr. Bushra, learned APP Assam, K. Bushra.
K. Bushra Lordship.
And APP Assam appearing for the state. What about the informant?
Nothing, it's a 302 case.
302, okay. Record reveals that LCR has already been received. However, there is no indication as to whether paper book is ready in this case or not. Office to therefore expedite preparation of paper book and list the matter thereafter for necessary orders.
Object.
Item 13. May it please your lordship. The LCR appeal has been admitted and the LCR has been called for your lordship.
LCR has been received.
Yes.
We'll pass the same order then, let them expedite.
Say 302 matter, your lordship.
Yes. Heard Mr. Khatania, learned legal aid counsel appearing for the appellant, also heard Mr. K. Boisho, learned APP Assam appearing for the state. This appeal has already been admitted and the LCR has also been received. However, it appears that the paper book is yet to be prepared. Registry to therefore, expedite preparation of paper book and list the matter thereafter for necessary order.
Item 14.
That please your lordship. Lordship, and the appeal is convicted under section 302 and 34 for life, lordship, and in this case on last occasion, lordship, and asked me to produce the statement of the PW 1 and 5, lordship, but the already LCR is ready to send the High Court, lordship. That is why we could not collect.
Sorry, already?
Sending the High Court from the lower court, lordship. So that is why, lordship, we could not collect. But lordship, and I have gone through the judgment of the observation made by the learned court below, lordship, and kindly come to page number 21 of the appeal petition, lordship. Appeal petition. And para number 12, lordship. And lordship, and the Para number, Lordship, PW one and PW five, Lordship, there is no corroboration, Lordship, and there is the.
Objection for this anyway.
Yes.
I take your objection hearing.
I have the. I is there, Lordship,
Yes, you argue, please.
and Lordship and.
What is the conviction under?
Lordship, page number 21 and PW one, Lordship, para number 12.
What is the conviction in this case?
Lordship and life,
Under 144?
no, Lordship.
Then why aren't you mentioning the provision?
Lordship, as far Lordship judgment,
Is
Lordship.
it under 302?
Lordship,
You don't know that. You're not saying,
30 to 34.
30 to 34, Lordship.
you say that.
And
30 to 34. How many applicants are there?
Lordship one, and there is the 7 numbers of the convicted, Lordship, but right now, Lordship one.
So others are not before the court.
Lordship, I have no idea, Lordship. And perhaps, Lordship.
All
And
right.
the appel-
So what is the ground?
And Lordship, the appellant is a 70 years old person, Lordship, on the date of occurrence, Lordship, on Rahamali. And there is the conversation regarding the land dispute, Lordship, as per the allegation made in the FIR, Lordship. And Lordship, as per the Lordship, PW one is the informant, and he said the accused person assaulted his father with a heavy wooden object, Lordship. But as per the medical report, Lordship, there is no any sustained injury, there is no any external injuries there, Lordship. And other witnesses examined, Lordship, and the informant father, Lordship, and he has the 7 numbers of wife, Lordship. And all they have gone in, and one is died, Lordship, and that is why, Lordship, and he mentally, most of the time he remain mentally disorder, Lordship, and he's searching the wife of his wife, Lordship. And on the date of occurrence, Lordship, and to one, Lordship, the PW3, Lordship, and he's the one neighboring people, Lordship, and he stated para number, Lordship, 25 page number, and para number 16 of judgment, Lordship. Just last 2 lines, Lordship, I may read, Lordship. And he further stated that Shiraz Master and Jamaluddin asked Mataleb, that's the deceased, Lordship, and that why he has come. And the Mataleb only replied that he was searching for his wife. Thereafter, Shiraz Master called the sons of Mataleb Ali, and Mataleb Ali suddenly fell down on the ground, and after that, Lordship. But as per the informant, Lordship, and when he came to the place of occurrence, on that time, Lordship, and his father was already died, Lordship. But the PW2 and his son, Lordship, this is son, and he said, Lordship, and he was not died, and he was brought to the hospital, Lordship. And one thing, Lordship, and the person who assaulted his father, there is no specific allegation made in the affair, and to who fatal blow or kick or any assault, Lordship. There is nothing mentioned. And the petitioner appellant numbers, and he is the 7 numbers of accused, and total his serial is 7 numbers. And only just his name is in the FIR, Lordship. Otherwise, and he is the 70 years old person. And as per the medical, and page number 26 in judgment, and para number 18, there is nothing found any external injury. There is nothing, Lordship, and on property was not found.
Let us see the memo. How many injuries?
There is nothing, no injury. And
Lordship,
on
no
property,
LCR, as per the cause list, LCR is not there. But there's
And-
no office note.
in page number 26, para 18, Lordship, doctor. Found medical person, found over the body was not found. But informant said that a heavy wooden object assaulted his father.
LCR ko nahi dekha. It's
How many accused persons?
7, Lordship.
So no specific role ascribed. What is the common intent?
Lordship, because one of the co-accused, as per, don't have the brief, but I have collected from the objection. Co-accused has called the victim to the residence to discuss about a land dispute, land. So thereafter he was killed, and PW1 and PW5 are eyewitness to the occurrence, my lord. PW1 have seen the accused persons beating the accused person in heavy object, my lord. And as for the evidence of the doctor, he received injury on his skull, my lord,
Yeah,
a
but how
vital
many-
part of the
how many-
body.
No external injury.
Lordship, as per the evidence of the doctor, it's on the, no, I don't have the record actually. PW4. Wound over the body was not found. Fracture of the skull bone present over the upper middle part of the occipital lobe of the skull. Size 5 cm in length on transverse direction.
So that is only one fracture.
Yes, brain congested, hemorrhage and clotted blood present. Let the LCR come, my lord. Will take help. Lordship,
We have to, these are bail applications. No,
specific overtake may not be necessary, your lordship,
No, but where is the finding on common intent?
because they have regarding the land dispute. I have not gone through the entire records whether there was any land dispute as regards the parties, my lord.
But these are not relevant. The judgment has to show. Where is the finding of
Let
common
us see,
intent?
my lord. Let us see. Lordship, may kindly have a look at the evidence part, my lord, discussion part at page 41. After going through the above evidence, it is found that PW4 and 8 are the official witnesses. PW1 is the informant and eyewitness. PW5 is the brother of the informant who is also an eyewitness. PW2 and 3 are the sons of the deceased and are the post-occurrence witnesses. PW6 is one of the relative of the deceased and is also post-occurrence witnesses. PW7 is a post-occurrence declared. On perusal of the evidence of the MO, it is found that he conducted post-mortem examination on the dead body Matlab Ali. Rigor mortis present, so and so is regarding the injury, my lord. Lordship, page 44. More particular, page 45. Call upon their father to his house for discussing some boundary land dispute. After 1 hour, they heard some halla in the house of Raham Ali. Then when they went to the place of occurrence, they saw that their father was assaulted by the accused Raham Ali and so wouldn't object. Thereafter, they some instance moved backward and informed their elder brother Aminul and uncle so and so. Regarding this discussion as regards 34, let us see, my lord, if I can find out something, my lord.
So what is the father's name of the applicant?
Lordship, Idris Ali, Lordship.
The oral dying
Somiruddin,
declaration.
Somiruddin,
Sorry?
Somiruddin.
Somiruddin. So see, the PW six has also named the sons of Idris Ali as the assailants.
Because if they are like, they had the common intent.
No, you please show us something which
Can it be day after tomorrow? I'll go through. I have not collect any papers with me today.
we'll do it tomorrow.
Tomorrow, my lord.
Yes.
I'll take a.
So and so for the applicant on the request of Ms. BVL and APP Assam appearing for the state, this matter is directed to be listed again tomorrow as a fixed item.
My lord. Published. Yes.
Tomorrow give the date.
May I please,
On
your
point,
lordship?
your student.
May I please, your lordship? My lord, in this case, I am appearing as legal aid counsel, my lord. Case has been already admitted, my lord, but the last date, my lord, your honorable court gives me instruction to submit regarding the point of extrajudicial confession, my lord. Because, my lord, this is the case of 302 IPC, and in this case, my lord, accused person convicted only on the basis of that extrajudicial confession and 313 statement, my lord. There is no direct evidence, no, but the eyewitness, my lord, our prosecution has failed to failed to prove the case beyond all reasonable doubt, my lord. It is a settled principle of law that, my lord,
So
only on.
this IA is for granting
Yes, my
bail.
lord, my lord,
So what is the conviction under which provision?
My lord. Application.
Conviction
my
is
lord.
under 302.
Yes, my lord. But my lord, application, my lord, kindly allow him to go on bail, my lord, during pendency of the criminal appeal. My lord, in this case, my lord,
You please point out on what ground you are seeking bail.
oh, my lord, in this case, my lord, after going through the evidence on record, your lordship will find that, my lord, there is no direct evidence, no eyewitness, only on the basis of extrajudicial confession and 313 statement, my lord, he was convicted, my lord. And in this regard, my lord, there are so many decisions regarding the point of extrajudicial confession, my lord.
313 statement is the basis of conviction.
No, Lord.
No, my lord.
No.
We'll have to engage an amicus. You're not giving us the facts.
My lord.
Another amicus to assist the court. Where are the facts? Give us the facts.
Yeah, my lord. My lord, in this case, what happened on 27/5, my lord? What happened?
What is the matter, Ms.
Lordship, in fact, I don't have the
You
brief
don't.
right now, Lordship. Lordship,
Nobody has the brief. Nobody is prepared.
Lordship,
No.
My lord, very simple, my lord, only I beg to submit, very simple, my lord. Informant's mother went to the
Lordship,
place of occurrence.
since Lordship LCO has been received, Lordship, Lordship may fix a short hearing date, or she will satisfy in that
No,
day,
no,
Lordship.
what short? We are sitting here to deal with these bail matters.
Lordship,
And then every
just-
matter, there is a request
then,
for adjournment.
Lordship, tomorrow then, Lordship,
Tomorrow, my lord. Tomorrow.
today itself, Lordship, just after some time,
Huh?
we'll go through the records, Lordship.
Next,
Tomorrow, what is the problem?
my lord, tomorrow, my sister's marriage, my lord. Tomorrow, reception will be going on. My lord, next week,
We will do it right now. We'll pass an order after going through the records. Give me the memo of April.
only on suspicion, my lord, FIR was lost. And no confessional statement was recorded, my lord. And he stated only villagers, my lord.
So the applicant has killed his mother.
Yes, Lordship.
Victim is the mother of the accused.
Yes, my lord.
Yes.
He went to the place of occurrence for breaking the stones only, my
And who is
lord.
the informant?
My lord,
Who is the informant?
informant, my lord, the son, my lord.
Informant is one of the sons. Lordship.
Very wrong, I couldn't.
One of the son of the victim mother, Lordship.
Manikanta Brahma, my lord. Yeah, no, this one, file is-
Otherwise, he has confessed under section 313 that he has committed this murder, Lordship. He killed.
Only treatment statement is not substantive piece of evidence, my lord, in case of such important case regarding murder.
Why did he do that? What is the motive?
Nothing. Yeah, so, you know. But the persons. Judgment portions also it's clear that, my lord, only 313 and the judicial confession based on.
So where is the evidence? The charge has not been proved.
Lordship, page 36, Lordship.
Hmm.
The last paragraph, Lordship, the last
Hmm.
few lines.
Yes.
From the evidence of PW5, it reveals that he found head injury on the head of the deceased Afang Brahma. Other witnesses also noticed head injury on the head of Afang Brahma. So the extrajudicial confession made by the accused regarding assault on the head of the deceased with a stone stands corroborated with the evidences of PW's, Lordship.
No,
Extrajudicial evidence, who has brought the extrajudicial confession?
Lordship, the accused.
No,
Who in-
accused is not a witness.
Yes, Lordship.
Who is the witness here?
Lordship.
Huh?
Before the villagers, Lordship, he has made the extrajudicial confession.
My lord, in our decision, it's clear, my lord. Extrajudicial, a person would confide about a crime committed by him only with such a person in whom he has implicit faith. Normally, a person would not make a confession to someone who is totally a stranger to him. Court has to be satisfied with reliability of confession, keeping in view circumstances in which it is made. As a matter of rule, corroboration is not required. In our case, my lord, only villagers he confessed. Only on suspicion, They asked.
No, who is the villager who has seen it?
On going through the evidence of PW2, PW3, PW6, and PW7, it reveals that in presence of them and the villagers, the accused confessed that he had killed the deceased by hitting with a stone. Though the defense side cross-examined them, but could not be able to dislodge their evidence. PW2 is the son of the deceased, and PW3, 6, and 7 are the villagers of the accused, as well as the informant of the case.
My lord. Prosecution based his case mainly on the extrajudicial
And
confession.
the 313 statement is there,
Lordship.
is it on record?
Lordship, in the judgment itself, page 37, Lordship.
Hmm.
Paragraph 39. During
That's right, the court has observed it, but
Yes.
where is this 313 statement? Is it on record?
Statement, Lordship. Perhaps that is not there.
So, the evidence. Hmm. Then- So if there is a reliable extrajudicial confession and if the
Lordship.
accused has accepted it in the 313,
Yes,
then
Lordship.
that's the end of the matter.
Yes.
There's no question of writing.
Yes, no good.
But without the LCR, we can't, do you have
Yes.
the?
My lord,
313.
after going to get the 313 statement বিলাক আছে আছে sir sir. ৰবা হা।
LCR is there.
Assamese,
পঢ়ি দিয়ক। 313.
তাকেতো ৰবা চাই আছো হা। Deviation নহয়। মই সেইদিনা পাইছিলো আৰু এটা আছে ৰবা দেই।
You come prepared then, we'll have it on Thursday. And get us some judgments also.
Lordship.
313 can't be the basis of conviction.
Lordship.
But if it is supported by other evidence, then the matter would be.
Lordship, otherwise from the judgment itself, it reveals the other prosecution witnesses is
Please Go
supported.
through the record and come. Ms.
Lordship.
Leonard, legal aid counsel is present on behalf of the applicant stroke appellant on the request of Ms. S.H. Bora Leonard, APP Assam, appearing for the state. This matter is directed to be listed again on 7th of December 2023 as a fixed item for
Lordship.
orders. You come prepared.
Highly obliged.
Obliged.
So what is this? Why there is no hearing list in this bench? Hmm. No, but no, there is no hearing matter today in the list. This is 11:45. We have nothing to do. You please ask the bench register to clarify. Please ask him. This can't be a list of a division bench in the on a Monday. I thought there is a hearing list, original hearing list. 15 matters. Yes, if it is not there, it must be there from tomorrow.